You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Wills and Probate podcast. Today I'm chatting all things probate with Charlotte Toogood, Legal Services Director at King's Court Trust, a topic that you are very familiar with, Charlotte, a topic that a lot of our listeners are also very familiar with. Probably there's some shared frustrations as well, no doubt. We're going to talk about some case studies, some different strategies and coping mechanisms, and some client management as well over the course of the discussion. So I'm really appreciative of you joining the podcast. Thank you.
No problem at all, David.
In the first instance, tell us about yourself. Who are you, and a bit about your role at KCT as well.
So as you said, I'm the Legal Services Director at King's Court Trust. I'm a qualified solicitor and STEP qualified practitioner, and I've been working in this industry for 16 years. Hard to believe sometimes because they fly. But yeah, 16 years doing estate administration, and 9.5 of those years have been at King's Court Trust. From the experience that I have come across a lot of estates, from simple to complex, but also, unfortunately, as we all know, a lot of those do turn contentious, or contentious matters come up on them, which is frustrating not only for the practitioners, but also for your clients and for the beneficiaries. So it's the big impact it has on everybody involved in estate administration, really. My role at King's Court Trust is I get heavily involved with our case managers in terms of technical support for those weird and wonderful queries, look at training for the team, having a look, obviously, what the latest, what do we need to make sure everyone is upskilled on, and really just supporting on the estates and looking at everything and coming up for the best way forward for your clients and the beneficiaries, ultimately to get the estate closed as soon as possible, because it's most of the time it's obviously everyone's grieving, and the sooner the estate's finalised, that's one part of the grieving process that they have dealt with.
We'll almost certainly talk about delays at some point in the course of the conversation, but I wanted to come back to one of the things that you said there, which is this anecdotal evidence. And I think there's now empirical evidence as well that says that probate is becoming more contentious. What do you think the reasons are behind that?
So I think more people are aware that there is the potential to seek legal advice if they're not happy with something they're getting under an estate. A lot more people have got access to obviously what they read in the press, but there's always that neighbour, that friend down the road who came across this estate and they weren't left what they thought they would, and it was successful and they got more money. Also as well, I just think people are more likely with blended families to look at things and say they're not happy with it, and actually not just to walk away. They will go that extra step and maybe get some advice, or for example, put a caveat in, which is so easy to do now. It can be done online. It can be done obviously in paper for £3. So if somebody wants to do something like that, it isn't going to cost them a lot to do the initial step. Doesn't mean it's going to go anywhere, but they've obviously headed down that pathway to be like, actually, I am unhappy, and I don't think for whatever reason the will, the rules of intestacy are being dealt with correctly.
Is it your view that as will writers and as skilled practitioners, there's anything that we can be doing to ward that off at the pass in some way, that we should be writing our clauses in some way? What are you seeing in terms of the nature of some of those contested estates?
I think a lot of the time when there's potentially a will and it's a blended family, individuals, beneficiaries are finding out about their inheritance at the point of death when someone's passed away, rather than conversations being having in lifetime when someone said, I've written my will and this is what's happening. And you can see potentially why, because perhaps an individual knows that someone might potentially be unhappy with it, or they think, do you know what, I will leave this to the professionals to deal with when the time comes and I pass away. I think more broken families, blended families is having an impact. We're seeing more of that. A lot of the estates that we come across, sometimes they can literally just be fighting over chattels. It's nothing of any real value, but it's the principle. Mum said I could have that necklace. Somebody else say, no, mum promised me that, then a granddaughter getting involved. And then something which is really trivia in terms of the whole of the estate administration, not so much sentimental, and obviously emotions play a big part in it, then ends up delaying the estate and potentially increasing more costs if they do decide to go the next avenue and seek legal opinions.
I did a wonderful podcast not too long ago, actually, with a contentious practitioner at a firm in Cornwall, Hayley Gaffney at Codes. And she was saying to me that the 5 most expensive words in the English language are, it's a matter of principle.
Yeah, 100% agree. They will just fight and fight. That's when and they'll just say it's a principle, and you just look at it. And as a practitioner, I'd look at it and you just see the costs going up, but clients, sometimes they just won't back down.
You talked about caveats and some of the delays of getting grants are due to the fact that these caveats are going into the estate administration. What examples have you got where there are delays as a result of those?
There's a correct reason to place a caveat, which should normally be, for example, if there's a will, if you don't think someone's got the capacity, or the will that's being proved, put to the registry, isn't the latest one. But what we find is a lot of people will put a caveat on because they're unhappy with something that they're getting under the estate. So it's I'm only getting £100,000. Mum promised me everything. That is really the wrong use of a caveat. That can be all dealt with by putting a claim on the estate. But as soon as that caveat is running, any grant application goes into the registry, and we will just get a response back from them saying a caveat's been placed by this individual. So then you're looking at going off on another branch to say, right, how are we going to deal with this caveat? Having to speak to our client, saying, right, caveat's been placed. This is the individual that placed it. You need to get some independent advice from a contentious specialist in terms of what to do. Do we ask them to remove it? Were you aware of this? That creates at least a month's delay just to have those conversations, even if the other party just removes it off their own back. And we all know about, obviously, the delays at the probate registry at the moment. It then sits in another pot at the registry until the caveat's removed, and then it gets added to their workload to work it through. So you start at the bottom of the pile again, really.
What comes out of a number of the conversations that I have through the podcasts is there's a huge amount of education that still needs to happen with individuals that are going through this process. And, you've alluded to the fact that people are going through a bereavement, and often, that we're not in the right state of mind to deal with things at that point in time. But do you think that perhaps people that are placing caveats don't really understand the implications of that decision?
I think placing a caveat can be really impulsive. And like I said earlier, it's really simple to do. So they do it, they pay their £3, the caveat's placed, and they think, great, I've delayed the grant application. But then they're not aware of all the other implications that has, because they could just be the beneficiary. So they don't actually realise, right, no one can get the grant now to deal with any of the other assets, to sell the property, to collect the shares in. And they've just done that impulse action, which then has a knock-on effect, which, again, the educational piece, you don't see the educational piece out there in the press for your lay people to say, here is what happens when you place a caveat. It's all about inheritance, people not receiving what they think they are due to receive. You can place a caveat.
There's a huge amount in the press, national press, not just niche press like ours, about estate planning, about lasting powers of attorney, and about trusts and general estate planning. As a practitioner, do you read that and do you find that helpful, or is some of the advice a little bit hit and miss? What's your view of what's out there?
I think there is so many different opinions out there, and as a professional, I know the opinions which I believe are correct and the ones that you can see, oh, I wouldn't be saying that. But you can then see as a layperson how people believe what they read in the press, don't they? And it depends, obviously, what they're reading. People get into conversations with friends and who haven't got any expertise in this area, and it's very easy, and we get it sometimes to say, oh, my friend got a grant within 3 months, why haven't we got the grant through yet? Keeping your next door neighbour as the expert in this because they've gone through it last. And actually, every estate's different, every contentious estate's different, and the reasons for an estate becoming contentious is always different. So it's really hard to get a party line, I think, out to everyone so they know actually what they should be doing.
But as a profession, we have a responsibility, don't we, to make sure that the information we're putting out is accurate, is fair, and is reflective of what should be happening, as you say, the right way and the wrong way.
Yeah, exactly. And I mean, so at King's Court Trust, all of our estates, we send a estate administration guide out at the start of the process, and it's a 20-page document which covers an overview of everything in estate administration. So, for example, if there's a section in there on contentious estates, it might go to a client and the estate never becomes contentious. But we know if an estate does become contentious, we can signpost our client to that guide and say, have a read of this. Because when you're talking through things with clients on the phone, it's a lot of information. And some people, they'll only hear bits that they want to hear. So it's always nice, and I find that to follow everything up in writing, but also to point them in the direction of something which isn't necessarily linked to their estate, but gives them the background of why things are happening and what the impact of that is. So it's a snapshot rather than actually the emotional side, which is links back to their estate.
Feels like a bit of a whistle-stop tour around some of the challenges that we face in
because when you do it, there's just so much. Like I was doing my notes and I was like, bullet point, I was like, oh my gosh, there's that, and then that can go off on this. It is such a wide area, isn't there? And it covers so much stuff.
And there's a multitude of challenges in there as well. And we've talked about a handful of them. What other challenges do you come across when it comes to dealing with probate?
A lot of the challenge can be the delays, so obviously anything contentious that it takes in terms of dealing with the estate and finalising it. And obviously the longer the estate takes to finalise, the makeup of the estate changes. So for example, you've got shares and property values. For estate administration, we're valuing them at date of death for obtaining the value at probate, but obviously they are changing. So the longer the estate goes on, the change that happens. But also, for example, a property. So if you've got a property in an estate, the executors need to make sure that they are insuring the property. Unoccupied insurance, there's no one living there, is expensive. Making sure you're maintaining it if it's through the winter months. Also, just the actual time spent to keep checking on the property and making sure there's weekly visits to make sure nothing's happened, there's been no break-in. All of this is taking longer whilst there are contentious elements potentially running behind, even if it's to the fact where it's not even contentious that anybody's placed a caveat, but where it's free beneficiaries who will say, I will only accept this offer on the property, and none of them will agree when any property offers get put to them. And then you're just constantly going round in a circle to say, in the best interest of the estate, you either need to agree, or the executor needs to take a step back and say, I'm named on the grant, and I, as authority, I'm going to make sure that this is the best possible price and accept it. Potentially one of the beneficiaries might be unhappy, but otherwise you're never going to progress and never going to get the estate finalised. Obviously, we're probably all aware, obviously, inheritance tax, if we can't realise the assets to pay it, it's going to be sat there with interest increasing. We've actually recently had an estate where it was taxable and a family member put a caveat in, but also wrote to all the institutions advising them that there was a caveat put in and not to deal with any of the assets. And this is the first time I've come across it.
Wow.
So the banks would not release any of the money for the IHT. Whereas we were just trying to get some IHT on account at HMRC, regardless of the fact that about the grant, just to stop the interest running. But the banks, institutions would not release any of it, even though it was going directly to HMRC. And that is the first time I've ever seen that. Normally, the institutions are happy because they pay it directly to HMRC. They know it's not coming to a professional. But no, the other side have written to these letters, and for whatever reason, the team at the institutions obviously probably looked at the risk of it and thought, do you know what, it's not worth sending any money. And literally we're just at a standstill for ages until we could get the caveat removed. Wow. But that had cost implications because there was an extra £5,000 interest just sat there because we couldn't get any money on account, and our clients didn't have any money in their own right to pay money on there. So yeah, it was a really interesting one, but really one that we sort of banging my head against the wall thinking, well, there isn't actually anything we can do here.
But Darius, how did you resolve that one then?
So in the end, we literally was just waiting until, so our client and the other side, obviously both instructed professionals, and then once the caveat was removed and everyone agreed, they were happy for us to go ahead, get the grant, they would deal with the claim issue aside, because there shouldn't, just because there's a claim on the estate, shouldn't stop the estate administration progressing. Ultimately, why the claim's ongoing, you want to be as a professional collecting in all the funds. So it's sat there in the client account. You can provide estate accounts to both parties so everyone can see what's going on. And then when the claim's settled, the estate, you would hope, would be then ready to distribute in line with the settlement and everything's dealt with, rather than waiting for the claim to settle before you then deal with any of the assets. I mean, there might be some assets you can't deal with if it's obviously the property and that's an element they're arguing over, but you don't want it just sat there stagnant whilst you're waiting for the contentious element to be resolved.
And of course, Bank of England interest rates have hit an all-time high over the past couple of years as well, and HMRC are taking advantage of that with their interest rates on IHT as well.
Well, exactly that. The interest rate is the highest it's been since I've been working in the area. I mean, remember a time when there was zero interest on IHT. I mean, a while ago. But yeah, it's literally very far from it now. So it is costing money on a daily basis for not paying your IHT off, which is frustrating when there is money there that could pay it.
One of the things I always think about when it comes to the sale of the property, as an example, and especially when you get down to quibbling over perhaps even a few £1,000s, is the cost of keeping that property for that extended period while you're quibbling. And you're nodding along because it's obviously something that you recognise. But let's say there's still a mortgage on the property, £600, £700, £800, and the sale is delayed a further 3 months. Well, that's £2,500 that you've paid out on a mortgage that negates the money that you might have sold the property for, over the course of that period of time. It becomes a bit of a point of principle, which is going back to what we said earlier, I think, isn't it?
Yeah, exactly. And I think it's sometimes you're explaining to your client, yeah, on the face of it, we can completely see why somebody is potentially obviously unhappy with what's being proposed. But when you look at the numbers, they'll speak the truth in terms of actually, is this going to have any benefit to anybody if you are all arguing over, like you say, £3,000 to £5,000 on a property when you've got so much there that's going to change in that period of time, that any savings you made, you're probably actually worse off by actually thinking, do you know what, let's just set £5,000 less and let's get this through quickly. Everyone will be happy, the estate can be distributed, and everyone can try and move on with their lives rather than have this hanging over them as well.
Family dynamics are very, very challenging. How do you, as an organisation, and you talked about your role as training as well and making sure that your staff are upskilled, how do you support staff in managing some of those expectations, managing some of those client challenges? But we're in an era now where you simply don't accept the way that people might have spoken to you 10, 15 years ago. Clients might have spoken to you 10, 15 years ago.
As much as the individuals, you need your technical knowledge, it's also having the soft skills, being able to communicate with clients. You can't have one approach to every client because everybody is different. So we'll make sure that obviously we do train clients on the customer journey. I mean, the first thing that I always say to everyone is obviously you are dealing with people at the worst possible time in their lives. They've lost a loved one. So some clients will be the person that you're dealing with is someone that they've probably not known before because they're grieving. And we've had it before where a client 18 months down the line has completely turned around and be like, I'm so sorry from day one. It was all emotional. And I think it's remaining professional and trying to say to them, you're there to support them. One thing that I say is always, if you're having phone calls, which most of our contact will initially be phone calls, and if it is something technical that you're speaking to them about, or you can just get a gauge that actually they don't fully understand, follow it up in writing and give them some bullet points to digest and get them to come back to you and say, actually, yes, I do understand. If we've got more than one client that we're speaking to, try and get people in on conference calls and Teams calls so everyone's hearing the same message and everyone's hearing what individuals are asking, because a lot of the time it's easy for us to get stuck in the middle of a family feud when clients turn around and say, oh, well, what did my sister say, or what did my brother say, or what did my niece say? So if you could communicate with everyone at exactly the same time, they're all getting the same information, and that nobody can think, oh, you're acting for them more, when we are completely neutral. So the more we can get them involved together, the easier the journey becomes. But that doesn't stop the people emailing you an email and you read it and you think, wow, okay, let's pick up the phone. And then when you pick up the phone, they're completely different to the email and the tone that they were in the email because they let their frustrations out. So, but again, it's giving them the chance to vent at you and then taking a step back as a neutral party and saying, okay, what do you want to achieve by this? What is your end result? Can we help you? Or actually, let's point you in the right direction of a contentious specialist who can actually help you on that journey to understand, is it worth pursuing really?
How many times have you come across that where somebody has hidden behind social media or an email, and the way in which it's delivered is really quite difficult to deal with, and yet when you get them on the phone, it's a completely different story.
Individuals got busy lives, so if they're dealing as a personal representative, they don't a lot of the time know how much time it involves, so they're emailing you out of hours. So you come in, open your emails on the first thing on a Monday, and you've got 5 emails from clients over the weekend. Clients have had the time to send all this information across, and you pick up the phone and get hold of them. They're like, oh yeah, it wasn't as urgent I thought it was, but I just want to get all this information across to you whilst I had the time. So we try and schedule in regular monthly updates at the same time so we can work around the client, so they know exactly when they're going to speak to their personal estate manager, so they can get in that routine of not putting everything down in an email and not being able to then worrying about it because they can't get an answer.
What do you do for your staff? What do you do internally to support staff around some of this? I know as businesses, we've got to be very client centric, and, I'm sure we all are, but our people on the front line also take a huge amount of the brunt of some of these frustrations as well. What do you do at KCT to support staff?
So it's just making sure that all the staff have got the support of their line manager, so regular reviews. We do something called a case clinic now every week, so the PEMs can bring to us any tricky estates for us to look at as a whole, and a group of us. And it's not necessarily the technical elements, it's also how do you manage client expectations, etc. So you can get more people's opinions, because somebody else might look at it and say, have you tried this? I tried this on my estate with this client, and it works really well, because rather than it's sitting, you can see people in the clinics, like the weight lifts off their shoulders when they're like, I've got this estate, what do? I don't know how to progress it. What's the best, what would you do? And then between us, we discuss it, and actually you can say, do you know what, that's really useful? And then they'll come back a week or two later and do you know that really worked? And actually now we have moved the estate forward, and the customers really happy now with the progression. We're looking to get this estate moved to the next part of the distribution. So those works really well. And again, obviously a lot of companies now, we have mental health first aiders. So if anybody wants an independent conversation, they can go away from their desk, obviously completely confidential, because even though it's not an estate of a loved one you're dealing with, it still takes its toll when you're doing it day in, day out, when you are speaking to individuals who have lost someone, and sometimes some estates and which tragic deaths, and the makeup of the family as well make it a lot more complicated.
And certainly since the pandemic, it's you have this hybrid working style, and there's pros and cons to it. Absolutely. I mean, I hear an awful lot, particularly in legal services, about the power of learning by osmosis, the difference between sitting at home and perhaps learning in front of a learning management system or a Teams channel, or as you do with your best practice sessions, as opposed to sitting in the office, perhaps in a traditional firm with the partner, sat opposite you or whatever it might be. How do you manage that in KCT? Have you got a hybrid working environment? Do you encourage people to be in the office? How does that work with you guys?
So we've got a real mix in terms of employees. So we have hybrid for people that are, say, local to the Bristol area. So they do come in to the office 2 or 3 days a week and then work from home. But then we also have people that are home workers 100% of the time, and they've been recruited on that. So those individuals, it's just making sure that we're still having those regular daily catch-ups with them, just to say, hi, how are you? Most of the individuals are in a team, so they'll have like a Teams chat with just a general quick fire questions on there if anyone's got questions. Obviously we do a lot of training, and we recently started doing our home workers training together, rather than mixing training where you've got people in the office and then people joining on Teams, keeping the sessions separate, because then we find that the interaction's better, because you haven't got so many people in a room and then people at home. And that was fed back to us by the employees, and that's working really well actually, because you've got the same type of individuals being remote or at the home being able to ask questions. So we just tailor make it, looking at doing smaller groups if we're doing really technical sessions, so everyone's got the opportunity to ask questions. And we ask for a lot of feedback from our actual employees, because they're the best people that can tell us what's working well and what do they want to see improved.
I said we'd come on to probate delays. And while I appreciate there's not a huge amount we can do about some of the challenges we face with the probate registry, I guess I wanted to ask you about what we as practitioners can do to alleviate some of those delays. And then, secondly, what clients might be able to do as well. What's your experience there?
So I think for us as practitioners, it's making sure when we're submitting applications, we are submitting them correctly. So, for example, wills and the conditions of wills are always an issue that potentially can get a stop on a case if there looks like there's been a staple removed, or if there's any wording in there which says this will applies to my assets in England and Wales. So just making sure we're covering everything off to make sure when it gets to the registry, it goes down their workflow to get it looked at and the grant issued, etc., as soon as possible. For clients, it's different because obviously they don't need to have the level of expertise. They're instructing a professional to deal with the estate. But ultimately, it's about being open with us when they're instructing us. So if they do know that the family dynamics aren't great, telling us as soon as possible so we can get a feel for, okay, do you want to get some advice now about any potential contentious elements, rather than we submit the grant application and then we get notified that a caveat's been placed. And a lot of the time, just pick up the phone to the client and the client goes, oh, I knew my brother was going to do that. And you think, why didn't you tell us that 2 months earlier, when we could have perhaps started, you could have started a conversation with your brother, or we could have said to our client, do you want to have a conversation with a contentious expert to see if there is anything that we can do? Because we've lost 2 months then whilst why the grant application is sat at the registry. So I think it all comes down to communication, but it's two-way. Obviously, we need to make sure we're asking the right questions, need to make sure we're probing to obviously get information about the family is as important as obviously getting information about the estate, because ultimately at some point in time you're going to have to deal with those beneficiaries, notify them of their inheritance, etc. So the sooner we know that, one, they're all on board, that we're dealing, two, they're happy with the inheritance they're getting, the sooner any issues are going to come out the woodwork, which means the sooner we know about issues, the sooner that we can address them.
And you can tease some of that out in those initial conversations, I suppose. If you know what you're looking for, you can ask the right and leading questions.
Yeah, exactly that. Like, for example, so obviously letter of wishes. A lot of us obviously are fully aware that a letter of wishes isn't a public document. So if we're looking at a letter of wishes in front of us that says something like, oh, the reason my son is only getting a legacy rather than part of the residuary estate is because we had no relationship and years before I was passing away, then we can speak to our client about that and say, look, this letter of wishes, your brother isn't going to find out about this, for example, but what is your relationship like? Does he know about the will? Does he know that he's only getting a legacy, or are we going to be the first people to tell them? And a lot of the time the clients turn around and say, oh no, can you, I don't want to keep causing any upset in the family, which of course we will write out to all the beneficiaries, but then we can time it as actually when's the best time to tell them, to find out if it's going to cause any issues later down the line.
So, in the spirit of sharing best practice, and one of the things I particularly like about the podcast is I think we bring some shared experience to the table as well. You know, we all face similar challenges in our working day, and I don't suppose that a huge amount of what you've talked about today, Charlotte, is alien to the listeners. But can you perhaps, just to finish the podcast, give us a case study, an example of a particularly complex matter that you took from start through to finish, and some of the challenges that you faced and hurdles that you overcame?
Yeah, so we see more and more contentious estates coming our way, but I think this one really sticks with me just because it was a really sad estate. So it was a sudden death. Our client was the wife, and it was a second marriage, and she had her baby 2 weeks before her husband passed away. She was dealing with not only having her own first newborn, but also the death of her husband very suddenly. And there were adult children from a previous marriage. The issue with this one was they got married, it was roughly about a year before. He had had a will, but obviously he'd got married, so the will had been revoked. So his adult children were really put out by this because under the rules of intestacy and due to the high value of the estate, they were actually getting less than what their father had put in the will for their now stepmom. At the time that he wrote the will, they were just partners. But we obviously had a client who had a very young child, was grieving for the sudden loss of her husband and just didn't know what to do. Where each call, she was just in tears, just being like, this is the worst time of my life. It should be the best time of my life. I thought I had a good relationship with these two adult children. And obviously, a lot of us will know. And unfortunately, death brings out the worst in people. And this was a true case of it. What we did really was support her from day one. She knew that these two adult kids were annoyed and she was open and honest with us. So we arranged a conference call. We said to her, look, make sure you've got someone on the call to support you as well, obviously, because there's a lot of information to take in and we need to make sure that we flow this through as quickly as possible for you, but also to make sure we're getting the support. So we arranged for a contentious expert to join the call with us. She made sure she had a friend to help her just in case there were any questions. And between the four of us, we sat down and actually looked at the estate as a whole in terms of the assets. What would the kids be now getting under the intestacy rules? What would they have got under the will? So we knew where they were, what they were going to potentially make a claim for. Whilst this was all going on, as expected, the two older children instructed a solicitor. So in came a letter from them saying that they put a caveat on and they're going to be making a claim against the estate. So actually, it worked well in the fact that they had gone away and got advice as soon as possible. And we all knew that they were going to make a claim, but we had a professional to deal with, so we could put it in the hands of the professionals to actually look at legally where does everyone stand and make sure it followed the correct process. So once our client was happy with who she instructed on behalf of the estate, it was then a case of King's Court Trust making sure we could get the estate valued as soon as possible, so all parties knew actually what was in the estate and what does everyone need to be provided for. But also our client was really worried she was going to lose a family home. She was like, I'm going to be homeless with a newborn baby. Just the uncertainty of all of that was obviously making this time even harder for her. Whereas the adult children had stepped away from the family, weren't living in the family home, but kept coming back and say, well, that was our family home. We don't want our stepmom being there. We want to have the opportunity to have this house as part of our inheritance. And so it was becoming, like you said earlier, David, a lot about principles. It was all very emotional about what they wanted and why they wanted it. Everyone agreed that we could go ahead and get the grant because obviously that was in the best interest of the estate. Our client was worried about having any funds to access just to live. She was like, I'm on maternity leave. This was never in the plan when we had a young baby. So she wanted to make sure she had some funds to be able to live on, which actually the other side were very accommodating to. And as soon as we collected some funds in, they said, yep, we can release you a small distribution from the estate so you can continue to live. Whilst all this was going on, we then had a friend come out the woodwork to say, oh, actually, also, I lent the deceased some money and he still owes me this loan back, which nobody knew anything about, but she had evidence. So it was another element to say to everyone, okay, right, we need to build this into the picture. Obviously, that's going to decrease the value of the estate. But the whole benefit of this estate was we had professionals instructed as soon as possible. There wasn't the adult children and our client trying to negotiate between themselves. They were too emotional to be able to do that, to be perfectly honest. And they were actually saw sense from day one to actually go and get the help now. I think it still took us though about 14 months from the date of death to actually agree what each party would have. So wow. We started collecting in some of the assets, but we still couldn't do anything with the house. It took us longer then to obviously deal with the shares and sell the shares and collect all the assets in, because they were still arguing. They started using the fact that, well, I want this particular item of my dad's, otherwise we're not going to agree to this. I want this particular item, otherwise we're not going to agree to this. To be fair, by the end of it, our client was like, they can just have what they want. I just want to be able to get this estate finalised so I can try and move on with my life. Everyone was happy at the end, and the estate got finalised. Obviously, there was cost implications. Our client obviously had her costs. The other two adult children had their costs. So again, there was a lot more money spent that there needed to be. It's obviously, it just went straight down the rules of intestacy. But I think just the fact that it was a sudden death and no one knows what's around the corner, and the fact that obviously there was this newborn baby in the whole picture just meant our client wasn't in the right frame of mind throughout, and was just really grateful actually for the support, and that we all worked together. Every time we had a call with the contentious probate specialist, we were on the call as well, so we knew, did anyone need anything from us? Did they need updated estate accounts? Was there any asset values they needed? Do we need to ask anything else of any institutions? So we could get it moving as soon as possible, because the sooner this was dealt with, the sooner it could be finalised and everyone could move on.
And of course, one of the other things that we were talking about just before we started to record this was that mediation is always an option, it's always open in these sorts of scenarios. And of course, your contentious practitioner is likely to make that recommendation as well before you start spending hundreds of thousands of pounds on these sorts of matters, Charlotte. It's a really, really interesting case study, and I'm very, very grateful for you joining the podcast. Thank you. I think what I take away from today is, like so much of life, this is all about communication. It's all about understanding your clients, understanding what your clients are looking for, and being able to communicate back to them how you're going to deliver that, and how you're going to ultimately help them through what, as we've both said, is usually an incredibly difficult time for people. So thank you so much for sharing your expertise and your insight.
No, you are more than welcome, David.
The Today's Wills and Probate podcast is available on your preferred podcast provider. It's also available on today'swillsandprobate.co.uk. My thanks to Charlotte. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at today'swillsandprobate.co.uk, and follow us on LinkedIn and Twitter.